Still in
Good evening. Being 4 o'clock, we'll start this meeting. Does everybody have the information around the commissioners, planning commission, and committee, frac sand committee? You have it? Okay. Otherwise, I've got some extra copies in the backpack there that you can have. Tonight, I thought what we'd do is committee as a whole. I just want to give you maybe a little brush up. What you have before you is what basically staff has put together with a lot of input from the study committee. We gathered, not saying that it's inclusive. I'm not saying this thing is set in stone, but it's up for discussion. We needed, as we thought as staff, to start putting something down that can be discussed and ran through. Like I said, we as staff put a lot of effort in what you have before you, but like I said, and I had some discussions, there's been some points brought up in regard to how do we include existing quarries in with, and how we bring them into the ordinance as it stands now, how to address those existing quarries and how they relate to the industrial mining. That took some time and effort to put together, and beyond probably what staff could do, and the board did approve us working with an attorney as far as trying to get a handle on that issue. So that is, like I said, what we did was try to put down what he had put in red. We colored them on different things and made side notes so that you would kind of get a handle on what was all discussed or what was being discussed. The other side of it is, you'll notice there's some clerical errors in the pre-pack or pre-application. I know we took a look at different counties, their ordinances. We looked at not only what's in Minnesota, but in Wisconsin, what's working, what's not working. Like I said, staff put a lot of time in on those, what you have before you. But like I said, it's not anything I want you to at least start thinking it's in concrete. It's not. And that's why I thought maybe tonight, bringing all three boards together, we'd have an idea from as far as the commissioners. I know we've got a couple of them that just started on the board to Planning Commission, and I know you guys have been following it, but there's been a lot of discussion in the frac sand committee. A lot of things have been talked on, such things as the water issues, air issues, health issues, road issues, and we tried to, like I said, put that all in. But anyway, I think the next thing I'd like to do, first of all, anybody's got cell phones on, please turn them off. We don't need those ringing. The other side of it is, maybe what we could do is go around the room and have some introductions as far as, whether Commissioner, Planning Commission, or the frac sand committee.
Hi, I'm Steve Schultz. I'm Commissioner, District 3.
Teresa Walter, Commissioner 4.
Judy Sterling, Commissioner from District 1. Long day.
Dana Chomey, Commissioner, District 5. Justin Zemieski, Commissioner, District 2.
Ron Miners, Manager of Water Conservation District.
Kelly Stanage, Frac Sand Study Committee.
Rich Hill, frac sand study committee.
Dan Griffin, Planning Commission.
Glenn Cruz, Planning Commission and the frac sand study committee.
Arlen Pullman, frac sand study committee.
Dick O'Brunson, frac sand study committee.
Charlie Weiser, Planning Commission. Jerry Rosendahl, Planning Commission.
Char Miners, County Auditor.
Carla Bowl, Planning Commission.
Eric Johnson, frac sand study committee.
Bruce Lee, Planning
Planning Commission.
Bob Scanlon, Frac Sand Study Committee.
Steve Beach, frac sand committee.
Ryan Bogazinski, County Engineer.
Thank you. The next thing I want to do is, I know this takes a lot of time, and there's a lot of other things that a lot of people have to do, but I want to thank you for at least giving up your time for this important issue. I think what we'll do is kind of make this as a working session. What the intent here is for the public to probably come up to speed as far as, and to stay tuned of what the discussions, but I'm looking at most of the questions that we have, concerns that's being presented, probably be left that to the Planning Commission, the County Board, and the Frac Sand Study Committee. We will probably end up giving some time, maybe after we get through the documents, if there's time allowed for the public then to ask some questions, but as of right now, this is just a study group, and what we're trying to do is get through the documents. It's a lot to ask in this short period of time of what's being presented. So with that, I'll introduce Jay Squires. Jay has represented the county in different things and helped us in a lot of legal aspects when it comes to land use decisions and opinions. I've known Jay for a number of years, all the way back to when you first started maybe land use with the county planning and zoning people. That's been quite a few years ago. And he comes from a new firm, I think. I'll let you take that off. But anyway, Jay and I discussed this here, and I think what we'll do is we'll walk through. I handed out an agenda that we'll kind of we'll try to stick to, and he'll walk through. Those are kind of the meat of the issues that we thought that probably should be discussed tonight. And like I said, if you got a question as we're walking through this on any of the from any of the committees, please speak up. And then what we'll do is if you can't, the rest of you can't hear, we can always repeat that question. So, Jay?
Good afternoon. Actually, it's been 23 years, Rick.
Okay.
But just a few. I'm with Rupp Anderson, Squires, and Walsberger. Just a little bit of background about myself. I've been practicing in the land use area for 23 years, representing counties, both in litigation and then in things like this, helping counties in day-to-day issues that arise in the area of land use and helping them out with ordinances. And as Rick mentioned as well, the county and the county board have asked me to assist you in your process of getting to the point where you have some good, solid, logical, defensible ordinances in place that deal with mining and deal with some of the new issues that are presented with some of the frac sand mining proposals that the county has seen and probably will see in the future as well. Also, as Rick mentioned, really the purpose of this is to talk about some of the higher level issues. So I'll throw some things out, and we don't have all the answers, but I think as we talk about some of these issues, I'd prefer not for this to be me being a talking head. We're looking to get comments from the members of the committee, the Planning Commission, the County Board, on some of these issues as we talk about alternatives, as we talk about some of the suggestions I have on some of the higher level issues. So I think what you should have, and I just want to make sure everybody has those, you should have an agenda with some attachments that I'll refer to as we walk through things, some statutes and some other materials. And then you should have a copy of each of the two ordinances, the industrial and the non-industrial mining, as well as the road maintenance and use and improvement agreement, and then an application packet. And it's those documents, the two ordinances, the road agreement and the application packet that Rick forwarded up to me, and that we'll spend some time on today in talking about some of those issues. As you probably noticed, the two ordinances are largely parallel. They relate to different things, but most of the provisions are the same. So I think as we walk through them, as we talk about particular issues under one ordinance, they'll be directly pertinent to the other ones, so we won't cross the same or cover the same issues twice. We'll focus I think in my judgment, we'll use the industrial ordinance and we'll talk about the particular provisions and how they work. The first issue, and I'd like to stick to the agenda, and again, feel free to stop me and ask questions or throw out a concern that you have. I'll note them, and I think staff will note them too, because as this ordinance gets continuing work, I think Rick needs to know what your concerns are as he works with you beyond this evening. So let's talk first about one of the most, as I reviewed the ordinance, one of the higher level issues or recommendations that I have, and that is to change the nature of the permit that you would issue for mining operations. And as the ordinance draft was presented to me, it required the issuance of a conditional use permit for mining operations. And for those of you who are not as familiar with the way conditional use permits work, just a couple minutes on background. The county zoning ordinance in each zoning district has a list of permitted uses and a list of conditional uses. The permitted uses, someone can go into this zoning department and pull a permit and be able to do that. The list of conditional uses, if you're not familiar with the process, most of you probably are, especially County Board Planning Commission members, but that requires an applicant to come in and come before the Planning Commission and County Board and demonstrate that they meet certain standards in the ordinance. And the second important feature is that the county then has the opportunity to impose conditions or limitations on the particular use. A number of years ago, and that's the first attachment in your materials, back in 2008, the legislature added another arrow to the quiver of county land use regulations, and that's something called interim uses and interim use permits. The question had always been presented. The statute dealing with conditional use permits says conditional use permits run with the land. They're recorded with the county recorder, so as property may change hands, the new owner still has a right to do those same things. The new owner may be a person who you have less confidence can do the job than the prior owner that came in. And you also have concerns about being able to have some end date of a particular use, as the county might change and the comprehensive plan might suggest that a use should be sunsetted. Well, in response to that, then, and those questions about with a conditional use permit, can we really make it personal? Can we establish a 5-year limit or a 10-year limit on the permit? The legislature added this provision and created a permit called an interim use permit. And as the statute says there in front of you, an interim use is a temporary use of property until a particular date, until the occurrence of a particular event, which could be a transfer of property, or until zoning regulations no longer permit that particular use. So through the concept of an interim use permit versus a conditional use permit, as mining applications would come in, the county board would have the discretion to be able to say, this permit is only good for so long as you, the applicant and operator, operate or use the property. If you transfer it, the new operator will have to come in and apply for a new permit and then give the county the opportunity to exercise some scrutiny over that operation and how they conduct their affairs and their past performance on other projects and whatnot. And it also gives you an opportunity to be able to put a durational limit on permits as well. Now you have to be careful a little bit. The statute doesn't give any guidance on how long they can be, but I would say that if someone comes in with an application and needs financing of $5 million to be able to do that, the bank probably isn't going to advance the money if they know the county issues a 1-year permit. So there's a balance of reasonableness in there in terms of durational limits, but the interim use permit really gives us flexibility to be able to approach the permit in those respects. you had a question.
A couple of questions on this.
Mhm.
In terms of an interim use permit, in the Houston County ordinance book, the big fat book, interim uses are assigned to feedlot rules specifically. So if we add this as an interim use, we might be confusing it with feedlot in our ordinances. And then the second thing is that there were a number of things developed with regard to conditional use permits in Houston County. It's clear that an awful lot of thought has gone into what needs to be considered when considering a conditional use permit. And one of the particular list of things is the findings of fact that are attached to conditional use permits. And I think it's really important that if we change what we're doing, how we are permitting industrial sand mining, I think it's very important that we need to take those findings of fact and also include them as considerations in an industrial sand mining permit.
Yeah, that's a good comment. And in fact, the way typically interim use provisions in an ordinance are drafted is they don't regurgitate and restate all those same things. They simply reference those provisions regarding conditional use permits and really think of it as the permits are identical with the exception of the added ability to be able to impose durational limits and make them personal to the applicant.
I did not see that reference though in the new industrial sand mining ordinance. I didn't see a reference to the findings of fact for a conditional use permit.
Yeah, we, now, just in a vacuum, I reviewed these ordinances. The point you're making is a valid one, and that is, as we, if the decision of the committee and the county board ultimately is to utilize interim use permits, we also need to tweak other provisions of the ordinance that generally deal with interim use permits and tie them all together. So that hasn't been done yet, only because I was looking only at the four corners of these documents for the purpose of today.
What's the process to tweak this that could change that document?
Well, the process, whenever you amend an ordinance, there's a process required by statute where you have hearings, you give notices, and then it goes through the planning commission for a recommendation, and then the county board adopts it. It's the same process as would apply to these documents. So it would run parallel. It wouldn't be consecutive, it wouldn't add to the time for doing things. But that would just be another thing that would run at the same time.
And you said that one of the things you can do with an interim use permit is you can tie it to a particular date. That an interim use is a temporary use of property until a particular date. And it's one of the things that we've talked about in the frac sand study committee is saying, okay, this activity, this mining activity starts on this date, and I've always thought that we should identify an end date, but that's something that we haven't been able to come to agreement on. And if this allows you to do that, I don't see that reflected in the current industrial sand mining ordinance, but I think that would be a very good idea because all of the reclamation activity is tied to the end of the operation, mining operation. Unless you have a specific date, it's very difficult to do that.
Yeah, and I think certainly in that regard, one option is to deal with some of these issues through the ordinance and establish general rules, but that's probably an example where each mining operation is different. It's a different operator, it's a different size of parcel, it's maybe a different commodity. So I would suggest that probably the more logical and common option is to determine that end date on a case-by-case basis as a particular permit is presented to the county and analyzed. That one of the conditions that would be considered if the county board chooses to use interim uses is to then decide what should the end date be for this particular application. And I think generally when you try to balance the interests of the operator, the county, the neighbors, that from my experience, and I just throw this out for editorial, from my experience having some mechanism in there where there's some understanding and certainty that this a project will move along and there will be an end date when these end-use plans and reclamation plans are implemented, that isn't necessarily a bad thing. So I think that's a trickle-down benefit of using an interim use permit and being able to say, here's the end date. And then we all have something to work for. I think we're not taking questions from the audience. I think that was the rule that was established. This was just a committee discussion, and people are certainly allowed to observe. Maybe at the end, if we have some time, we can do that.
Yeah, just in conjunction with the interim versus a conditional use permit. And I've been involved in aggregate mining for 39 years, so over the years, but what I've seen or wanted to make sure the board would keep in mind is that you do have aggregate locations that can run for 100 years as far as the reserves and the mining. And you can have a quarry here in Houston County that's been there for 50 years and will have reserves available for the community for another 50 years. So it's not all bad to look at it from the standpoint of a long term, because when you do look at wanting to develop natural resource for the use for the county and the townships and stuff, you want to ensure that you won't be shut down after a certain time frame, whether it be 1 year, 5 years, or whatever, if you're going to invest the money into the development, go through the process of being in the aggregate business.
Yeah, those are valid points, and it's related to the point I made earlier that establishing too short of a durational limit really might not be practical or reasonable in a given case. But I'll throw out these ideas. I'm not going to give you answers, but I think just to play the devil's advocate on the other side, yeah, maybe a particular mine or property would take 100 years, but why can't a permit be issued for 50 and have the operator come in after 50 years and get another permit? Because I don't know what the community is going to be like in 5 years or 10 years or 20 years, what other uses might spring up around the area. So these are all things to talk for the committee to talk about in, do we want to go the direction of a permit that authorizes us to impose durational limits, and should we talk about what those limits might be and what some of the criteria are that we would look at in imposing durational limits on mining operations. So I'm going to give you a lot of food for thought. I'm not going to give you an answer and say it should be 32 years in every case. But I think it's just helpful for me to get some information to the committee to be able to think about what do we want to do in that area on these higher level issues.
If I could just follow up with one more question. Would it be reasonable for the, I understand that each case is going to be different. That's completely reasonable. But would it be reasonable also to have the actual ordinance require that an end date be stipulated on the permit? If that's the way we go.
Yeah, I think it really is a question of whether the county boards, it's in the nature of a reminder or a flag that each permit shall have an end date.
Right.
I think probably for the reasons I mentioned, to specify that in an ordinance is probably not consistent with the fact that each application and operation is different. But you certainly could say in the ordinance that one of the conditions shall be the end date as established by the county board. And then that kind of calls to the county board's attention when an application comes through. One of the things they have to do is put that date in there, based on the facts and circumstances in that case.
Then if that is the case, I don't understand the real benefit of using an interim use, I guess.
Well, the benefit, again, is that you have that ability to put that end date. If it's a conditional use, arguably, it can go on forever. 100 years, 200 years.
So the benefit is the end date. Gotcha.
And making
Thank
it
you.
personal as well, and that's subdivision 1 again. An interim use is the use of property until a particular date or the occurrence of a particular event, which is the transfer of property, and that's the notion of making it personal.
So recently, we've had a company buy out another company who was in the quarry business. Buy out all the locations. Now, does that require all those conditional uses to be, or interim uses to be canceled out and start over?
It depends upon what your ordinance says. If that's the trigger, No, I use the word transfer. I'm just using words. You can use whatever words you want in identifying what the particular event is. So that's a topic for discussion, I think, of this committee about what do you want to be the particular events then that will say the new person has to come in. Now, it's not that the new person can't do it forever, it's that they have to come in and go through the process again.
But doesn't that give the quarries value to have a permitted site? I mean, if somebody wanted to sell out, retire, sell out, but a buyer sees that, okay, if it's an interim use, that's gonna get pulled if I buy it, so there's no value there.
Yeah, typically what would happen, oftentimes, as happens when any other developer or buyer of property wants to come in and use the property for their particular purposes, usually they come through a process and their agreement with the property owner is contingent on getting all those permits and approvals in place. So I think it's just a question of procedure and logistics that, yeah, it certainly is different than a conditional use permit where an operator could, or someone that's looking at a new operation could say, yes, they've got a valid conditional use permit, they can do that, I can buy it, and the next day just hit the ground running and do the same things. It sets up a different process, certainly.
Unless the county doesn't approve of the new buyers.
That's right.
But that'd be ahead of time. Be subject to.
They could apply for the conditional use permit before they bought it, and if it was granted, they could buy it, right?
Yeah, and this is, everything that we're going to talk about balances the interests of the parties that are involved in this. Certainly, I recognize it's a different dynamic for someone who wants to then sell an ongoing operation to have to go through this process. On the other hand, I say, as I point out the benefits to the regulator, the county, to be able to scrutinize the new proposal, flesh out the details. Maybe the reclamation plans will change, other things will change. Maybe there need to be adjustments in security and bonds, given the nature of the new operator. It's an opportunity to be able to deal with all those different issues at the time of the sale.
So if an owner dies, the resource is gone?
No, again, I'm not defining the particular event. That could be within the definition of a particular event or not. So, and the ordinance could say if someone dies, even if there isn't a transfer of the property, say it stays in the family and the son continues to operate it. I suppose you could say that's a triggering event where someone then has to come in and re-up for a permit, or you could choose not to.
Jay, if that occurred, though, I think you'd kick in the EAW or EIS requirement on a rock quarry or sand pit, because you're going to come back in for a new conditional use permit. Then the Minnesota statute's going to take over, and you would actually have done a environmental assessment worksheet, let's say, but you change ownership, you're coming back in and doing the same thing. So again, in the way this document is written, the things that are being said are in this one, so we'd want to change what we're looking at if we're going to try to mitigate some of these concerns.
Yeah, there certainly are little details that would have to be tied up with this approach, and that's a good point. Any other questions about that? I'm just going to move through these and we'll talk about them, and then hopefully we'll have time at the end as well for questions and maybe questions of the residents, people out in the public as well. The second issue, and probably this is the more meaty one that I've looked at and have dealt with Rick and Bob on, and that's the issue of non-conforming, or I think as you call them in Houston County, registered mines. I think it's the same thing. So when you use that phrase registered, I think what's being referred to is operations that pre-existed the adoption of the ordinance. The second document I've attached to your agenda materials for your reference is the Minnesota statute on the regulation of nonconformities. I wanted to spend a couple minutes making sure we're all on the same page so we understand what a nonconformity is. A terminology registered mine, nonconformity. Nonconformity is a general term which refers to something that was legal at one time. It complied with whatever ordinances existed or not, but now isn't legal because the county has changed the ordinance or its rules. So it was legal, but it's no longer legal. You can have a non-conforming use, which is a use of property. Say the county zoned a particular district business, and someone had a business there, that was great. But then they changed the zoning designation of that area to residential. So now there's a business in a residential district. That's a non-conforming use because the use of the property doesn't meet the use requirements of the ordinance. You can have, and the second term under non-conformities, the broad term, is non-conforming structure, sometimes called substandard structure. So that would be an example where a house was built on a residentially zoned property, say it was built 2 feet from the property line, then the county adopts an ordinance that says you have to be 10 feet from the property line. So that house, and they didn't change the residential designation, so that house still is a conforming use, still residential in a residential district, but it's a non-conforming structure or substandard structure because it doesn't meet the performance standards of the ordinance. So just some background. Hopefully I'm not going to run out of juice here. Did you lose me? Try that. Just got to knock it every now and then. So those are the particular terms that, as we talk about this concept, make sure we have in mind so we're all talking the same language. Also, an important consideration is that I think many people believe that if something is non-conforming, and the most common term is grandfather, this is grandfathered in, you've heard that term. Really, that's the concept of nonconformity and nonconforming uses and structures under state law. There's a common conception that if that's the case, they can do that property owner can do essentially anything they want, and the county can't apply regulations to them. That's not correct. The county still has the ability to be able to regulate nonconformities, and that's the statute in subdivision 2 there in 394.36 that I've attached to your agenda materials. The county board by ordinance may adopt such regulations not contrary to law as it deems desirable or necessary to classify, regulate, control, reduce the number or extent of, and provide for the gradual elimination of nonconformities, again the broad term, and occupancies, including requiring nonconformities to conform with the official controls of the county or to terminate within a reasonable period of time. So we need to all be on the same page on the front end that the county does have the ability to adopt reasonable regulations as they would pertain to registered mines, whatever the nature may be. And with that background, I'd like you to turn to the industrial ordinance, and I want to walk you through the key features, and it's on page 2. This is probably the most substantive area where I just took some initiative based on having dealt with the county and other counties on issues of non-conforming mines, and put in some provisions for the committee's consideration that would deal with the issue of registered mines. And what I'd like to do is just walk you through those particular provisions. So if you have page 2 in front of you with all the, Rick made the color copies, it should be red and blue. Right, did you get colored copies?
Yeah.
Did they get colored copies?
Yeah, there's all colored
Okay.
copies.
So the title would be Interim Permit Requirements, and Subdivision 1 and Subdivision 2 is additional language that I've thrown out for the committee to chew on the issue of what to do with not just registered mines, but I've also lumped in here mines that have had a conditional use permit for some period of time, and what might happen in a situation where there would be what I would call a desire to convert the nature of that operation from what they had been doing historically to something different. And subdivision 1, prior conditional use permits, recognizes the existence of particular permits. But in the last sentence in that, you can see is the operative one that says, any expansion or change in the operation shall require a new, and I see I missed an interim one, we'll have some polishing up to do, as Rick mentioned, shall require a new, if you choose to go interim use permits, and new interim use permit. So expansion or change in the operation. And what we would do is probably tie in and have a definition of expansion that gave staff and enforcement some more guidance on what that did. But in terms of the concept that I wanted you to understand as you would discuss in the future this particular provision, it's designed to recognize that those mines that have conditional use permits may continue to operate as they have operated. But if someone comes in and changes the nature of that operation or expands, they would have to come through the process and obtain a permit to effect those changes.
Excuse me, Jay.
Yep.
Conditional use permits, it's my understanding, are good for 5 years, I believe. So this would only apply for 5 years if they wanted to change the use to industrial sand mining.
Yeah, those provisions that deal with that 5-year term need to be adjusted as well. And I don't know that that's a topic for discussion here today, but...
So you mean the conditional use permitting ordinance also needs to be adjusted?
Yeah, the provisions that talk about mines and conditional use permits. Again, I'm looking at just this document. There are other things that we would need to do with the ordinance to bring it all together. But these are the big issues that we felt we wanted to talk about today.
Well, the reason I raised the question is now we've got grandfathered mines and quasi-grandfathered CUP mines, right? And interim use permits. So the conditional use permit mines are kind of quasi-grandfathered in until they expire? Is that correct?
There is no word that says expire in the old literature.
Yeah, that's some of the verbiage that we have to deal with. But I think there's not a meeting of the minds amongst the people that view that particular provision about how it actually works.
Okay.
We look at a conditional use to see if it's causing an issue, if there's a problem. Every 5 years.
Is that the 13 findings of fact that you use as problems?
15 for a conditional use.
But the notion, I believe, of this, as it would tie into those provisions that would be adjusted, is that if someone has a valid conditional use permit, as state law says, that they're allowed to continue, unless there's a concrete condition that establishes a duration limit, which, again, as I mentioned, is of our questionable, perhaps, authority, that generally speaking, that those would continue on, but they would not be allowed to change or expand or convert to another operation. The concept is it's a balance of the interests of the property owner to be able to continue with the operation and the interests of the county to be able to assure that that permit isn't utilized to be able to initiate a use that was never contemplated when the permit was first issued. And quite frankly, and this is true in Houston County, and from my experience, it's true in just about every county in the state. Land use decisions that were made 20 or 30 years ago were not made with the level of documentation and precision that they are today. So there is always some effort in looking at an old permit to try to understand what the original scope was. So this is designed to try to put the county in the best position to be able to deal with that.
Could we, just for a second, before we get to deep into this, can we go back to the first page of this?
Yep.
And under definitions, subdivision, excavation, and mining, and get through it, and then it says, the terms, keep going, the processing, washing, cleaning, screening, but we had talked that there was, is this a mistake that that's in there? Because in one of our documents that the study committee had, subdivision 3 prohibited activities. It was the washing, application of chemicals, effluents, the excavated or mined industrial minerals and metals is prohibited. So was this a mistake or?
Well, I don't know about the underlying language. I mean, some of these issues, again, maybe at the end, Rick can address some of those. I think some of these issues are going to have to be reserved for future discussions of the committee. My changes are noted in color, so if you have issues with the underlying staff draft, that may not necessarily be something I was involved in.
Okay.
So I think those issues you'll just have to hold on to and make note of as the committee continues to talk. That, like Rick mentioned, this apparently isn't in stone, so there are continuing discussions that need to be made on some of those issues. I'm just trying to assist you in some of these big issues that I think you need to look at as well.
Okay.
This is a pretty big issue, and I guess I'd like to understand if the document that you reviewed included prohibition on washing with water, processing, and the use of chemical flocculants, because it does not appear in this new document. And it doesn't appear as having been deleted either.
On page 4, it states, subdivision 335 prohibited activities.
Right, that's different than what was in the document that we reviewed on November 26th, our last meeting. It's very explicit in that document. The November 26th document read, it had 6 actual items under prohibited activities. Number 5 read, the washing or application of any chemicals or flocculants to excavated or mined industrial minerals or metals at the mining site is prohibited. Mining operators will be entitled to dry screen and sort industrial minerals or metals at the mining site, but must haul all excavated, mined, and or screened industrial minerals or metals to sites outside Houston County for further processing or washing. Number 6 reads, any materials brought back to the sites that have been processed with chemicals or flocculants is prohibited. Any haulback material is subject to testing at the owner and or operator's expense. And these were items that were directed by the board, I believe, for the frac sand study committee to include in the document, and they don't appear. So I think this is an important topic for us to.
And I'm not disputing that. I'm suggesting it probably needs to be an important topic for you to continue to chew on. It wasn't based on, you can see my track changes. The document I reviewed didn't have 5 and 6. So I don't know what happened there, but you'll need to, as a committee, look at that issue and figure out.
I just have a question for the Board of Commissioners. Was that a directive, or was that in stone that it was supposed to be banned?
No, it was a recommendation.
Directive to what, the study committee?
To the study committee.
See, Jack relayed that to us, that you agreed that it was to be banned.
As a recommendation, though, we can't legally make an ordinance that tells you that.
Well, at that meeting that Kelly was talking about, he made it sound like it was a.
I'll read the minutes if you want, just to clarify. Yeah. It just says, motion was made and seconded to unanimously carry to direct the study committee to develop the ordinance to disallow the use of water processing, prohibit the use of chemicals and mining to the depth of the water table.
That's from the board meeting?
Yep.
Commissioners meeting?
Yes.
But not the study committee?
Nope, that was for the board of commissioners.
Do you have the minutes from that study committee?
I do not.
They quit doing minutes in August. There have been no minutes posted since August. If you, I mean, they're not out on the web anyway, I haven't seen them.
We'll just move on because I know that's,
I can't help with any of this. You'll have to, I think you'll have to sort this issue out. And ultimately, the board is the body that adopts the ordinance. So I think the board has to be involved in that dialogue, as it appears they have, so that the committees that have been formed perhaps have some indication of the leanings or directions of the board on that point. I'd be happy to work with you in looking at that language, but I've not been involved to this point.
I was going to say, do you have any thoughts on prohibiting washing and flocking usage and all that?
I guess I'd like to see some language that you apparently had drafted at some point and be able to digest it a bit. And
You know, I'd just make the comment, I think the committee felt all along that we should separate industrial sand mining from the aggregate mining. And so we've got to ensure, as we'd be talking about, not allowing any washing of processing of silica sand, where that doesn't flow on in through an ordinance onto the aggregate site.
Yeah, that would be a good
Washing,
example of
concrete
the-
sand, asphalt sand.
And that recommendation was, these were the highlighted areas have been updated. It's like 1126. And this was in section 27, which is the industrial, not in the construction.
so I think you want to make note of that issue, and that's an issue that the group needs to continue to talk about.
The activity that takes place in a, let's say, in a construction can also take place in the industrial, right?
I'm not sure I understand your question.
Well, what I'm asking is, like, say permitted use is like, we do allow washing in a, and my line of thinking here just is that we would allow washing because we do wash sand for septic systems, for, you know, sand that's gotta be, it's gotta meet certain standards, so it's gotta be washed. Same thing with our limestone, it's gotta be screened, a lot of it's washed for the fines to be out of it. So I'm asking, is that activity that if we allow it in a, if we would allow it in a construction, and they wanted to do that same activity in industrial, is that something that can take place?
Well, no, because you have two different ordinances that govern the two different activities. So as was pointed out, you may end up with different regulations that allow or don't allow certain things based on the ordinance. And I think as long as we have some rational basis for distinguishing between the nature of the activities, then it seems to me that's something that's reasonable.
And do you agree that it's reasonable to separate construction, mining, and industrial sand mining?
Yeah, I think this approach that you've taken is not unreasonable. I think that and I'm not a mining expert, I'm a land use attorney who understands land use issues and have come to understand mining to a certain degree. But as some of these issues of differences have been fleshed out, washing is one example where it may make sense to have differing regulations and rules that apply to them. Well, you could have one ordinance that has different subparts that deal with them, or special requirements that apply to one type of use. Or you could have two ordinances that largely are parallel but are different in those areas. I think either is reasonable. Answer your question? Let's get back to nonconformities. Subdivision 2, I wanted to explain the concepts in my mind behind some of these, behind this particular section. And the beginning largely parallels the concept of state law, legal non-conforming mines. Now, I say legal because just because something existed a long time ago doesn't mean it's a non-conformity. A non-conformity is something, remember, that was legal at one time and it's no longer legal. If, for example, someone installed a use on their property but never got the permits in the first instance, it's illegal and it's not a proper non-conformity. So legal non-conforming operations may continue provided the mining and extraction use does not expand beyond the boundaries of the legally described parcel in which the mining operation was established. And I can say that I think generally speaking, and this is more a matter of records of the Planning and Zoning Office, but as mines were registered and noted on the records, there was a legal description of a parcel for that registered mine that was attached to it. Generally speaking, I can't say whether there's an exception or not, but at least there's some county record that would be able to tie into a registered mine or a non-conforming mine that would say this is the parcel that they can continue to use. So the first sentence says they can't expand beyond those boundaries. And then the second sentence says they may not expand in the nature of the use. And as I think about it too, when I use the word expand, or propose to you to use the word expand in subdivision 1 with this conditional use permits that existed, it might make sense to have a definition that applies to 2. But I made an effort at a definition. Expand means increase in dimension, size, area, volume, or height of a structure, placement of a structure or part thereof where none existed, any addition of a site feature that would allow the land to be used more intensely, I think I might have a typo there, we'll have to work out that kink. Something of operations to a new location, be movement on the property, or increase in the intensity of use based on review of the original nature, function, or purpose of the non-conforming use, and tied in hours of operation, traffic, parking, noise, storage, signs, lighting, types of services, orders, area of operation, number of employees. You can see it gets a bit long, but it's an effort, and this is, I think, something that I would say to you, let's talk about this and chew on this and see how you feel about the language. But conceptually, I just wanted to get across the point that what I'm trying to do here is, A, recognize the rights of the registered mines if they are legal to continue to operate, but B, establish a rule that says that's what they can continue to do. If there are changes, if there are expansions as we define them, then they have to come through the process. And the county board has the right, through the planning commission, to be able to permit them and impose some of the requirements that otherwise would exist. The next sentence simply parrots state law, and that's in the statute that I provided to you. And I guess this is a topic for discussion too, because to be fair, I'll point out, I think county ordinances differ in this regard. This says that if operations are discontinued for a period of 12 months or more, that the nonconformity rights are lost. And I will say state law says that, but certainly with respect to mines, it's a little bit different than a use that's ongoing, like a business or a house where people continue to live there. Mining operations can be itinerant in nature, where maybe they won't have any activity for a period of time. So that's another area that I think the committee probably wants to think about, is there some other way that that should be approached to recognize that or not. And in my judgment, we would have the ability under state law to be able to establish a different rule, but I want you to flag that as an issue that needs to be discussed. But by the same token, if it truly is a use that has been discontinued, for example, there's a large pile of gravel on the property and there's a tree that's 12 inches in diameter growing up through the middle of the pile, that would suggest to me as a layperson that probably there hasn't been much going on for a long time. So I think that the county does have a regulatory interest in saying to those types of operations, you have to come through the process under the new ordinance. But by the same token, if you do have operations that have been consistently operated and may have a period that might be longer than 12 months, is there language that you can come up with to balance those interests? The next sentence says that non-conforming operations shall comply with the various performance standards in the ordinance. And remember when I read to you the provision in the nonconformity section and emphasized we still have the right to reasonably regulate nonconformities, that's one of the sentences in there. We have the right to apply our performance standards and the requirements of the ordinance. So again, dispel any notion that, oh, they're non-conforming, we can't make them do anything. We still have the right to be able to hold them to some of these standards, even of the new ordinance. And then the last provision, similar to that, and the notion of us having some level of authority, requires them, even the registered mines, to at least come in and submit a reclamation plan. And this goes to the notion of the county's interest and the interest maybe generally of neighbors and citizens to be able to at least require the registered mines to come in and demonstrate how this is going to end and what the property is going to look like as well. So it imposes that requirement, and I wanted to point that out. The next subpart is a subpart that I would say probably is one of the more aggressive suggestions I have to you. And that is the county board, when it regulates the use of land, does so to protect the health, safety, and welfare. We probably can't come up with all the circumstances that might arise with a registered mine where we have thought of all these reasonable regulations that we can impose on them. So this is a catch-all that essentially says if the zoning department determines that there are environmental hazards, other significant health, safety, or welfare effects, or they fail to comply with some of the other standards of the ordinance, then we can make them come in and go through a process and get a permit and deal with some of those circumstances. So this certainly is probably more aggressive in terms of regulation than the prior paragraph, which largely parallels the provisions in that statute. But this is a provision that is, in substantially these terms, fairly common in county ordinances and in nonconformity sections, especially as they relate to mines. So I included that for your consideration as well.
So would I be right to say that this is giving the Board of Commissioners broad powers more than they ever had before?
Well, I don't know that I would state it that way. If the county has the authority to do this, I don't know that it gives them powers that they didn't have before. But certainly it gives the county board the authority to be able to bring those issues that exist with the current operation before them. That's correct. And it's a matter of policy. And I throw this out to you because I believe it's consistent with the statute. I believe it's still within the reasonable regulations, but obviously people have feelings about a general authority to be able to bring a matter before the board. And I think that's something that probably benefits everybody by talking through and determining if that's appropriate.
Back to this part where you talk about it hasn't been used for a period of 12 months. The county would have the right to shut that down.
Actually, state law says that already.
Yeah, I know, I understand that. So like, there's a lot of quarries around here that are been sitting idle. Not to say that at some point in time they could become active again. So in other words, if they're not being used for 12 months, they gotta start all over. I mean,
yeah, if the county were to adopt an ordinance that establishes this rule,
I mean, that's the
and
same
reinforces
for
state law,
rock quarries, too.
I think that would be the result, that if the facts suggested that the pre-existing use had been discontinued for 12 or more months, the consequence of that is they would have to come in through the permitting process. And that's why I suggest you just kind of call that out, is that something that you should, if you haven't talked about already, you should talk about with respect to mines, because mines are a bit unique in the transitory nature of the operation.
But that would be where, Eric, there would be a difference between between the construction mine and the industrial mine if we wanted to do
It's the
that.
same thing in the construction part too.
That could be changed to it. Because, the one thing that nobody wants to do is affect the quarries, that we use on occasion, right? I mean, you might have a rock quarry that sits for 2 years, 3 years, and there might be some small boxes growing in them, but, nothing much.
But in the new
and we
commercial,
wanna keep them.
in this new one, it's in there too.
But then maybe, if we have the opportunity to continue the study committee, then we can change that.
Maybe a question? I think it's going to be hard to change. I don't think you discriminate between one mine to the other. I think in a legal standpoint, I mean, we got an attorney up there, but I think, you could run into some lawsuit problems on that, wouldn't you?
Yeah,
You can't discriminate either.
Here's the rule I would suggest, that as you have each of these in front of you and you go through them, and you might see an area where, well, maybe we should be different on this one versus that one, you have to ask yourself the question, why? What's the basis for us being different? Is there some legitimate consideration that we can cite that causes us to believe this should be A and this should be B? So hold yourself to that standard, as opposed to just, let's change this one, but not that one, because we're running out of time, so we'll just leave that one the way it is. So I think if we're deliberative about it, and we do have a basis for the ordinances being different on certain points, flesh out why it is, and ultimately, when it comes up to the county board, those are important things for the board to be aware of as well, as they consider slightly different ordinances.
You didn't answer my question, though. Is there going to be a problem?
Well, I think I gave you a standard to employ to put you in the position of avoiding. Is there going to be a problem?
Is there going to be a problem? Yeah. Will there be a problem if you have two different regulations?
And I think my answer is, if you have a reasonable basis for concluding why this should be A and this should be B, then you're in a position to defend that. Do you want to guarantee that you'll never be sued? Can't give it to you.
Okay. No, I mean, but I know how the process goes, but.
In the land use area, I think being cognizant of the existing authority and the regulatory scheme, we put ourselves in the best position to have a good defensible ordinance. I think that's why the county board has wanted me to be involved, to provide this guidance to you, that as you do these things, you're mindful of some of the rules and limitations that apply. So, for example, on this point, if someone points to a difference, you can say, here's why it's different. And we talked about that at the committee and the planning commission and the county board, and that's a reasonable difference in this circumstance. That's what you need to have to be able to defend distinctions. And then the last provision in there, and this is designed uniquely at a particular element.
You gotta hold it kind of tighter here.
Am I back again? A particular element of operation that is processing, and that is to say that if a registered mine chooses to engage in processing, that they will have to come through the interim use permit process. So that really is, again, to kind of highlight the broad brush issues with respect to pre-existing CUPs and registered mines. They can continue as a CUP, but not expand or change the nature of the operation. They can continue as registered mines, but again, they can't expand or change in the nature of operations. Even registered mines have to give us reclamation plans. They have to meet certain standards. We impose some of this regulatory authority even on them because we have the ability to do that. And we have a general broad provision that says if something is going on an operation that implicates the public health, safety, or welfare, we have the ability to bring that registered mine before the county for some further analysis. Those are the concepts.
I'm sorry, I got it again. I just have a really dumb question here, and maybe it's a question for Rick. What is the difference between the red text, the blue text, and the orange text?
It's all online. It's all done at different times.
Okay.
I would like to be able to say I just sat there and I did it all in one afternoon, but sometimes you have to peck away at things as time allows.
And then just one kind of detailed question. The way that sentence in subdivision 2 is worded, legal non-conforming mining and extraction operations may not expand in the nature of the use. Oh no, the next sentence. For purposes of this section, expansion means any increase in a dimension, size, area, volume, or height of a structure. My question about that, couldn't dimension, size, area, volume, or height all be construed to be modifying a structure? So
That's just the first part. If you go on, it's a long run-on sentence. Go on to the second page, and it gets more broad than
placement of a
that.
structure, part thereof, intensely developed. Okay. And then, how do you establish, as you mentioned, these things have been done with varying levels of specificity for years, okay?
Yeah.
Long before Rick and Bob were in the department, okay, CUPs were issued that were perhaps not particularly specific. And so would it make sense to go back to the minutes from the planning and zoning meetings, et cetera, to try to put some specificity on what was the intended use so that the county is able to determine whether that has been exceeded in what is happening now?
If that's necessary in a given situation, am I on here? Tie it to my chin, I guess. Yes, there are fact issues based on the nature of the records, the detail of the records in a given use, that when it is necessary in a given case to ask the question, what was the nature of the non-conforming use or the use authorized by a conditional use permit 30 years ago? To be honest, sometimes there are challenges. I'm guessing Rick would say, I don't have the staff to go through all the records and do that just to have good records now. I think it's probably going to be a situation where when one of those issues arises, where it's necessary to figure out what was the nature of the use, the CUP that was issued 30 years ago. That's when you go back and you look at the minutes, you look at the application, you look at whatever other documents are available to you. You try to talk to, if people are still alive and around, you try to talk to people that have some knowledge, some historical information available to you. And you look at the trees that are 12 inches wide that are growing up in the sand. You look at aerial photos. That obviously has been more advantageous in recent years. But boy, in the last number of years when you have aerial photos, you get a pretty good idea of what's going on properties. So all that information, yes, it can be a challenge in a case, but that's what you have to do.
Wouldn't it make sense to try to forestall any problems by going through that exercise and have some conversations with landowners and come up with some agreements on what was the intended use so that you don't have to wait till you're sued?
Well, you can do that, and I'm going to defer to Rick and the county board, but he might say, give me 3 more staff people to do that, and I'd be happy to do that. That's really not for me. That's an issue with the budget and the staff ability to be able to do everything they have to do, and then that effort, which I think would be significant.
I agree, it's probably not a question for you, but given that there was unlimited budgeting and staffing, would that be a good idea, I guess is my question.
If there's unlimited budgeting and staffing, the county could accomplish a lot of things, that's for sure.
Well, I mean, I'm just saying, is that a good idea? Setting a baseline.
It's not for me to say. Of course, to have more information than less is always a good idea. But it's really for the county board and staffing issues that are really beyond me.
Thank you.
Let's talk next, just to kind of keep us moving along, about density restrictions. And maybe Rick, you can help me because I forgot to write down what section in the industrial ordinance establishes the quantitative limit of 6.
Page 10, Jay.
Great. Yep, there it is. Thank you. And let me give you a little bit of background as well on the breadth of our authority. We certainly have the ability to regulate the density of uses, any given use. 1 per 40, residential structures sound familiar? That's a density limitation on residential use in an agricultural district. So we have the general authority under state law to impose density restrictions on uses, which is another way of saying a quantitative limit. Whatever density restrictions we have, we know there are going to be only so many of these things in the county or in a certain area of the county. That authority has been more clear when it deals with what I call vice uses, alcohol, pawn shops, gun shops, tobacco shops, things like that. It's less clear when it comes to more general commercial operations. So one of the things, and maybe the committee's had this discussion already, whenever we pick a number, of course, someone always asks, why wasn't it 5? Why wasn't it 7? What's the rationale for 6? Whenever we adopt an ordinance, again, like our differences in the ordinance, we should always have some answer to why we have that quantitative limit to be able to support it. If someone says that's arbitrary, it's just a number that was picked. So I throw out, and this is an area where I don't know that I have the answer for you, but I would suggest that it would probably behoove the county to consider, are there other ways to approach this issue? So what is it that you're trying to accomplish by the quantitative limit? You don't want to have too many operations that in the aggregate or cumulatively adversely impact neighbors, surrounding properties, the environment. So you're trying to deal with that. But if you have if that's your goal, if you have a quantitative limit of 6, is that goal served if all 6 are clustered in one very small area of the county? Probably not for those neighbors. So, one could argue, I think, that just saying 6 in the whole county doesn't necessarily get to the heart of the evil that you're trying to address. So I just throw out, I don't know that I have the answers, but could you have a requirement that says no more than X within a certain geographical area and have the county carved up into districts? Or no more than X within a particular township? Or if the predominant concern that you have is the impact on roads, no more than X that directly access or dump their main traffic and gravel trucks onto, so that you don't have the cumulative traffic from more than 1 or more than 2 or more than 3 operations that impact one particular county road. Or could you say that they have to be at least Y miles apart, or whatever that distance may be? Or could you have a combination of both by saying only so many within a particular geographic area, and they all have to be so far apart, and they can't all dump on the road? All these mixes and matches I just throw out as I tried to brainstorm the idea. I would suggest to you that, in my opinion, and from my experience, that I think that some of those ideas might be better than just picking a number. And I don't know that we're going to have that dialogue today and you're going to figure that out. But I think as you try to nail down this ordinance finally, I think this section in particular is an area that you can put more thought into. And you might come up with some different approaches that, if someone asks that question, why do you have those provisions? Why do you have only so many within this area? Or why do you have this setback requirement? You can say, here's why. And then you have, I think, a better chance of, as I mentioned earlier, I can't guarantee you aren't sued, but you're in the most defensible position based on my experience and knowledge and judgment. So that's another area that I think, in my review of the ordinance, I think that you can develop further.
Okay, and if I could say, I would agree with you, the density, using the concerns as far as roads, environment, et cetera in there, I think also is a better way versus having a set density number, which like you said, I think, and down the road, even though it's not today or next year, but maybe 10 years from now, there'd be concerns about rock quarries and sand pits. And then you might say the same thing could come up where somebody would say, well, let's not have more than, instead of 100 locations in the county, let's not have more than 20. You know, and it'd be opening up a kind of a slippery slope for everybody to slide down with the density based on a number, not based on geology and based on then the concerns of transportation and environmental other regulations.
Yeah, and I point out, like I have tried to, on other points, it's always a balance of the various interests and rights in the area and the county's regulatory authority. So I think that this is an example as well where we try to balance the interests of property owners and free enterprise when it comes to businesses with the interests of the county in assuring that in the cumulative or in the aggregate, that operations don't harm neighbors and other properties and the environment and so on and so forth. And this density is certainly a legitimate topic for us to look at as one of our arrows in the quiver. But I think to really think more deeply about what we're trying to achieve and what harms we're trying to avoid and how we might approach it in different ways would behoove you. Those are the real broad brush topics in terms of the ordinance as it was presented to me that struck me as things that you needed to talk about. I wanted to go through the road upgrade and maintenance agreement and yes.
I don't know if there are any other questions there before we maybe.
Sure, yeah. Do you want to just focus on the ordinance first and then we'll go to this?
I think as long as we're on the two ordinances, if there's any other questions or concerns that the committees have.
Are we gonna go to the commercial and construction?
Well, that's what I'm saying, opening it, and we'll just leave the questions right now, we'll go through those two ordinances. You got additional questions?
No, that's fine.
And I would point out, I don't intend to go through the commercial one because as you'll see, all my changes are parallel. So all these issues that I've talked about, using an interim use permit as well as a CUP, the non-conforming issue, I don't recall the density. Did you have you didn't have a density limit in this one, so that would be different. What was given to me as the base document didn't have that.
So just to be clear, everything in the industrial ordinance is the same thing as in the commercial construction except for the density, correct?
Well,
no.
I can't say that for sure because I haven't gone through it with a fine-tooth comb. I'm talking about my changes.
Right, that's what.
These my changes, these broad brush issues for you to talk about. The IUP, yes, I made the same changes. The non-conformity, yes, I made the same changes. The density restriction issue, no, because that's different. No, I think you'll have to talk to Rick because I'm just working from the baseline document he sent me. If there may be other words that are different or provisions that are different.
I have a question from page 16 on the industrial. Annual registration required, number 2. Interim use permits for mineral extraction facilities will not automatically expire because there are no activities as authorized within a year's time as long as the permittee complies with the annual registration specified herein. Since one of the benefits of using the interim type of use permit is the actual end date, what does this mean? I just don't understand what that whole item means.
Well, I think when we were talking, and the reason that was put in there because of the industry itself, say, like it is now, where sand is all backing up and there is not as much activity going on in the stockpile. Say the mine does shut down for a couple of years, it doesn't automatically just go off the radar. I think that's what we were trying to get at.
That's where the end date becomes a problem.
Yeah, this is that's a good catch. This is something that also would need to be dealt with if the direction is to go with an interim use permit and establish a durational limit. And go with my non-conformity language.
So I'm sorry, what needs to be changed here?
We need to play with the .2612 per M2.
Okay.
Yeah, it's not, it's a good point you made. It's, yeah, it's conflicting.
Okay.
But I know, like I said, when we were discussing this thing, the idea came up that we don't want to turn around and just because the markets went off for a couple, 3 years, that, you know, all of a sudden they're, because they haven't mined in 12 months, that they're automatically shut down.
Yeah, but that's what it says in that one.
That's what we need to look
Yeah,
at.
we need to
Well, at what point,
harmonize those.
yeah, just curious, at what point can we say, start reclaiming this property? You haven't used it in X number of years. It looks to me like it's easier just to keep it going rather than spend the money to reclaim it. You know, at what point can we say it's time?
Yeah.
That's good.
Well, the discussion we had was, you know, on the frac stand, you're going to end up as, and part of the process is to basically have bonds in line to cover the cost of remediation. And then there's, what they were also looking at is probably fees for any acreage that's open. So you would be assessed an annual fee based on the amount of acreage that you have open. That fee would be then remitted to the county to basically enforce all the ordinances and the expenses that the county has dealing with the ordinance. So if you want to let 10 acres sitting there idle, you're going to be paying for that to stay idle.
Page 13 talks about.
Okay.
And that's the frac sand portion.
Talks about starting within 3 months after the termination of the mining operation.
I'm just saying they probably won't terminate it, it goes dormant, inactive.
Termination, discontinuance of such operation can be a period of 6 months.
Okay.
Or 3 months after the expiration of the mining interim use permits. So 3 different ways to return.
Yes, maybe I can make a comment here too. On these particular higher level issues, what would be very much helpful if I continue to work with Rick in refining the language is that if the committees or whoever's studying it could be very intentional in addressing these issues and document very clearly, here's how we want it to work. After you've had that discussion, I think we can come up with language then, instead of making you the scriveners and having to argue about should it say it here or is, to be able to make these high-level decisions and say, here's how we want it to work, and then we can come up with language for you to try to implement that. Question?
I think on the study committee, we talked about that in the reclamation plan that they had to submit when they started this mine, and that you could put the condition on there that when they had so much of it opened up, they had to start reclaiming it and not have everything left to the last end. That's got to be part of the reclamation plan when they submit. And you can control it pretty much, I would say, that way.
I think, didn't we talk too about 12 months? I mean, if there's no activity in 12 months, they had to start reclaiming. Part of the reason being they couldn't start reclaiming in the winter time or, you know, like that.
I think what we talked about is the 12-month thing was after they ceased operation at the mine.
What it
They
is,
had to be finished with it. That was part of the reclamation plan.
Yeah, page 13 talks about no more than 40 acres open, and it's starting within 3 months after discontinuance of operation for 6 months. So it's essentially 9 months.
Well, that's for the interim permitted mine, but we just talked about for non-conforming mines, it should be, it's listed as 12 months now, right?
It's listed, what do you mean by that?
On
The
page
reclamation
3
plan issue you're talking about?
No, well, lose any rights as non-conformities, I guess is
Yeah.
what it's saying, which I'm assuming means it must be reclaimed.
Yeah, we need to tie all these issues together. I think if, and this is an example where if the committee decides on this particular language about how do you want that to work in terms of existing mines, do you want the 12 months or do you want something different? I think we can then tie all these other provisions together and for example, coordinate that provision on reclamation plans and when that's triggered and how it is triggered by the discontinuance of a use back to there. So there are a lot of provisions that interrelate that probably need more work. I think I would suggest to you, again, the best way to handle it is make decisions on some of these big issues that I think still need further work. And then you can get drilling down into some of those details and make sure it all interrelates and is consistent.
What is your opinion then on, we're talking about land here that's privately owned, but it's not public lands, and the reclamation process, does the landowner have any say in the reclamation process, Bob or Rick or you or?
I think that
Well, the reclamation plan basically is something that's drafted by the landowner.
Well, it's by the mining company in the permitting
Well,
process,
who's
correct?
leasing to the mining company?
Right.
He should protect himself or should have some say into that, how he feels it should be.
So, but does the landowner have the final say, seeing how it's his land? And he should say, hey, I want to keep it like that instead of what you say I should do it like this?
maybe I can take a crack at it too. If you look at, starting at page 13, you look at 13 and 14, going on to 15, these proposed provisions are pretty typical of reclamation plan standards. So if your question is, since it's the landowner's land, can they have the reclamation plan look like and address whatever they want? The answer to that would be no, that there are requirements in here and standards and details and substantive requirements and procedures that have to be met. Those just, I think, as a matter of the committee too, going back to the concept of reasonableness, I think it's always good that if you have a standard that you want to apply to everybody, it should be in the ordinance. If you have a condition or limitation that might apply to use, might not, that's probably more the topic of attaching as a condition that's unique to a particular property. So as this ordinance was drafted, and you'll see I didn't do a lot with that, but as I read it, it appears to me that that if the county board were to adopt this language, that it would suggest that it's very interested in knowing how the reclamation is going to look. How's the property going to end up at the end of it, which, from my experience, is one of the bigger considerations for a county board.
So the county has the full authority to say on how this reclamation should look on this landowner's land, correct?
But I don't think it's arbitrary. It's pretty well spelled out what they want. It's not arbitrary. You gotta make your property look pristine to my standards. So it's spelled out here. A certain amount of,
It's spelled out here on how they want it to look, right?
But
stop shell, 3 inches stop shell, right?
If we did have some kind of rules, everybody would say, well, I like the way this looks right now, so this is my reclamation plan, is nothing. And then everybody would be staring at that eye, so I mean, there have to be some ways to take care of this.
What I heard you say, Jay, is that this is the minimum standards for everyone. A landowner may choose to go above these standards, but this is the minimum standards for reclamation, whatever's in the county ordinance, correct?
That's the way that I read the provisions, yeah. The ordinance says, here's how the reclamation plan is to look, here's what it's to contain, here's the process, the landowners to follow, yeah.
Number 2.
If you look at subdivision 6.2, I guess maybe this addresses to some level of concern. This is on page 15. changes in the plan. In the event the operator finds characteristics of the area are different, changes may be made in the original plan through the issuance of an amendment. I read that as giving maybe the county board some flexibility to recognize a changed circumstance or nuance to be able to allow some flexibility in that circumstance. So I would qualify that these are the standards, but that appears to provide, like a variance does in the land use process, some mechanism to be able to be flexible.
Before we leave industrial mining, on 16, inspections, violations, penalties, and enforcement. On inspection, in addition to recording requirements, the city, and I assume that's typo, may make inspections of the facility upon reasonable notice. Should that be worded like that? I mean, should the county be able to, if they suspect a violation, be able to just comment?
Well, I can say that every ordinance I've looked at has that general authority. And in the permit that's issued, I always suggest one of the standard conditions is that they agree that the county will be allowed to have reasonable access to be able to determine compliance with the zoning ordinance. But yeah, practically, if the property owner is standing at the property entrance with 2 pit bulls and the county staff are zoning there, are standing wanting to get on, and they call me, we probably say that might be a circumstance where we have to get an administrative warrant, like a search warrant that police get in the criminal area. So it just depends. You try to work with the property owners. You try to, from the county's perspective, get them to recognize that we have the ability to inspect and enforce. In 90% of the cases, it works out. If not, then we have to look at other alternatives.
Just on page 12, and it's a similar issue. When you start using words like reasonable and significant, they become less than meaningful. On page 12, it says mounting operators will not cause a significant reduction of surface water, and it used to say or groundwater from the mining site. So, like, what is significant? Is it 10%, 20%, 80%?
Depends on the facts and circumstances. Can you possibly come up with a general rule that says 14.2% reduction would trigger something? I think no, you can't, because there are situations that just vary. So inherent in the enforcement and administration of an ordinance, there are going to be circumstances where staff has to make a value judgment. So you can try to define and quantify everything. From my experience, I don't think that's possible. So I think having words in there that allow for some measure or require some measure of interpretation are fine, and they're common. You can qualify that by saying will not cause a significant reduction as determined by the county board or by county zoning staff, which some read as calling out more who's the one that makes that determination, and that's a better position to be in. So that's one way to approach it, but I think there just are examples of situations where you can't possibly include a quantitative standard.
Well, I guess
Objective
if we're
standard, I should
talking
say.
in most things like reasonable notice, maybe that one I would say yes. But if we're talking about our well water, I think you start wanting to be the quantity of our water. I think you want to start being specific about what significant means. Just a thought, because that's pretty important.
What if you say 10,000 and in a given case, a circumstance where it's gone down 9,000 still presents problems, and the county wants to say, that's a real issue, we have to deal with that? How do we handle that?
Set a minimum. I mean, I think when we're talking about water, we need to start being kind of specific. Because there's a point at which there's a worst case scenario that we do not want to allow to happen. I would imagine when it comes to, do I have water or not in my private well? Just a thought.
Yeah, and it's really not a legal issue for me. I think it's more for the committee. I think in instances where you say, I'll get you for this, Rick.
I got a little switch.
Where there is an ability to say, yes, there is one standard that should apply to everything, and it's easy to put that in there, then put that in there. There are going to be some situations where I think it's acceptable to have reasonable, substantial, significant, and so on. And I would leave that to your consideration, your deliberations to figure out. I'm okay from an attorney's perspective with there being subjective standards. It's not all objective. As one judge said, it wasn't this county, but in a case where someone was arguing something, the judge said, Mr. Nelson, are you suggesting that a zoning staff or the zoning office can be staffed completely by trained monkeys? That it's that easy? And it was a notion of there has to be subjective judgment that goes on. So that I think is the point, that there just are decisions that are made, and what's significant in one case might not be significant in another because they're unique variables.
Another area on page 12 that will have to be addressed, or doesn't have to be done now, but summer months versus winter months under hours of operation, the definition of those months and coming up with probably the actual months listed there. In the rock quarry business, we actually can crush primarily from, let's say, February 1st up until like Christmas time. So, and then whatever we can get for hours of operation, if they're longer, it can allow us to reduce our crushing costs and production costs. So that would just have to be addressed by everybody at some point.
Well, here's, again, yeah, those are good points, and that kind of ties into, if I can again throw out my recommendation to you to get through this process and to help facilitate it is meet as a committee, have the discussion, make deliberative decisions on these big issues that I presented to you, first order of business. Then go into some of these details and start working on the details that I wouldn't necessarily know anything about and I can't help you with. And I think that's the best way to approach it. Then you have the big issues nailed down, and behind you, we're working on language to get to you to finalize, and then you can just cross T's and dot I's and do all those other things. I think that's most likely to get you to the end of the process, instead of the tendency to get into a circular analysis by paralysis mode with something that's as big as this. Okay, we've revisited it, now you start talking about things that you thought were resolved again, and then it just never ends. I think focus on big issues, get them done, start working on the little details. Any other questions about the ordinance? Rick, did you want to allow the public to ask questions about the ordinance now, or do you want to wait until the very end?
Let's go through the road use. I
Okay.
want to get through the
All right.
portion of it all first. And then
Okay, I don't have, I think, Brian, I may have, what I got sent up to me may not have been the most recent version. I think as we pass chips in the night, so mine might have probably, there's more red in here than otherwise might have been in there, had I gotten the most recent version. But I'm only gonna, I don't know that I have a lot of bigger issues with the upgraded maintenance agreement. I think just to offer some commentary, it is a mechanism that again is referenced in the ordinances, so it's one of those documents that needs to be negotiated and worked through and implemented as part of the process. I think it is, in my judgment and opinion, it's a reasonable approach to identifying the particular issues that a particular project may create to assure that the county is made whole, that its transportation network is protected.
Yeah, just so everyone knows, the reason why Jaden had the most recent version, he was looking at the version that was in discussion with Minnesota Sands. So the only stuff that was missing was a couple paragraphs at the very beginning of the agreement, and then some of the stuff near the very end dealing with, I think it's dealing with some of the fee structures and bonding and that type of stuff. So everything in the middle should be very similar, so that way you know what's missing.
And you're planning on putting
Yeah, but
those
I actually
things back?
I gave Jay a copy of the most recent version,
Okay.
so he has seen it. I think some of that stuff got put back in here based on what he has, so.
Thank you.
I just want to, going along the general comments, as the agreement, I think with my changes, the approach of the agreement is to identify maintenance and require that there be money set aside up front and preserved in an account to deal with maintenance issues that might result from a project. And I think we have the authority to do that. Then there's the pot of money that may be necessary if particular improvements, an acceleration lane, a turn lane, a bypass lane, intersection improvements may be necessary based on the engineering analysis for a particular project. And again, I think we have the ability to do that. I think the key thing, concept for you to keep in mind as you go through this agreement is that it's important for us to focus on what impacts this project will have to the transportation network. We have a right to make ourselves whole so the county doesn't incur costs from this operation. We have a right to assure that the operation doesn't present traffic safety concerns and require them to fund improvements necessary to allow their project without posing those problems. But the analysis should be on this project. It shouldn't be just generally. And that leads me to just the one comment I had on the road agreement, and that is the provision that I'm not even sure is in the road agreement itself, but is in the application packet that creates in the nature of a traffic impact charge, where there's just a charge that's established by the county board that says if you have a mine, you'll pay this fee. And I've attached your materials a case that is about 10 years old or 15 years old, where the city of Egan had what they called a road transportation fee, where they just assessed a fee against every project and said, here's a fee that you're going to have to pay for the road system. And essentially the Supreme Court found that to be an improper tax. And what we're required to do then as a result of that, whenever we're imposing financial obligations on an operator to fund maintenance or improvement of the road network, we need to be able to establish that nexus. So my recommendation is not to come around this way and just have a standard generalized charge that may or may not be reflective of impacts of this project on the road system, but instead to have a system like you do in the road agreement, I think currently, that says we will analyze what impacts this project will have on our system, and then we'll require them to establish funds to assure that we can address those particular impacts. And I think that's a proper approach, and I think that's the approach you should take.
Can the business who wants to use the roads, can they be charged upfront for the analysis?
Yeah, I think that I could dig through here, and Brian, you probably lived this more than I did, but I think there are some cost recovery mechanisms in here where they pay for the analysis, and I think they produce report and data, and I think it even says if the county wants to go off and get someone else to review that they have to pay for that as well, as I recollect.
That's even included in under the, like say if there's an environmental assessment to be done, yeah, so the county does not get hooked like we have to pay for that every time to have that analysis done. Yeah, the applicant will, or the mining company will pay that back.
And that's a common provision when projects of this complexity are brought forward, and it's necessary for them to have professional consultants, and for the county as well, that it's the applicant that should pay those as opposed to the county's general fund and everybody else. So that's, I think, the way it's drafted, and that's very typical.
Can you talk about your recommendation as far as the county should require a bond in the amount of the roadway improvements, or collecting a fee based on mileage with no bonding up front, or a combination of both, road damage?
Well, I guess I would say my recommendation is that, one, we should have the money up front, the security in some fashion, whether it be cash or a bond or a letter of credit, whatever we have available to us that it allows us to tap into a pot of money. The form doesn't really matter to me too much. And then two, of course, that amount should be accessible and subject to our control. So if it's cash, we don't want the project operator to say, well, we'll hold the cash. Possession is 9/10 of the law. So A, we want a pot of money that's commensurate with the costs that we may incur, and B, we want to have a mechanism that we know if we need to, we can just simply go in there and tap into it, like a letter of credit, walk up to the bank and say, write us a check. So how you do that doesn't really matter to me so much, but those are the considerations.
So will there be two separate bonds, one for reclamation, one for roads? I mean, they're separate issues here.
I think it would make sense, although this is one of those, sometimes I sit in my office and I never see how things technically are done on the street. So I don't know the bonding companies that might issue a bond like this. I don't know what their considerations are in terms of whether they want separate bonds or they might want to issue one bond. If you're familiar with public projects, you have to get a payment and performance bond. When you have public projects, oftentimes those bonds are combined into one. So I just don't know how the sureties handle it procedurally. So that's something, maybe as we craft language, we want to make sure that it actually comports with the actual practices. So what we're requiring, come back and say, oh, my surety says that can't be done.
On the roadway side, would it be better to have probably actual cash up front for a letter of credit than an actual bond?
Cash is always better than a bond.
I mean, on a bond,
Because a surety company is like an insurance company. And I don't mean to offend anyone that's an insurance agent or anything, but the money going to the insurance company in forms of premiums flows very easily. The money coming back to you when it's necessary for them to write you a check doesn't flow quite the same way.
I was going to say, like a reclamation, you know if they reclaimed it or if they didn't. It's done or it's not. Roadway damage, every single car using that roadway is damaging the roadway to some extent. So you can get down to the end, and then you can say, the mine caused the damage to the road, and the mine can argue that they didn't cause any damage, it was all the rest of the road.
I guess think of it this way. The issuer of the bond stands in the shoes of the operator. So you may say the operator violated something and you have a right to access that. But the bond company, the surety, could say, no, we don't believe that's true. We've talked to our person and he disputes that. Well, then what do? Then you have to get involved in litigation, perhaps in the worst case. Whereas if you have the money, then it's a totally different scenario. Then the burden's shifted to them to then come after you and claim that you accessed it inappropriately. So I think in that sense, it's better to have cash, certainly.
This is kind of a philosophical question. I don't know whether this is going to come up, but I'd just like your input on it in case it does. Some insurance companies, and the one I know about specifically is Nationwide, has issued a policy that they will not insure any company related or any activities related to hydraulic fracturing. And one of those activities that they list in their policy statement is frac sand hauling. So if we're going to say you must have an insurance policy with the X coverages, and there's a trend that insurance companies are not going to be covering that activity, how would we need to change this road use agreement to accommodate that?
Okay.
It becomes complicated when there are nuances in the scope of coverage, because typically what we always do is we specify the coverage by nature, commercial general liability, automobile, workers' comp, and we specify all that with limits, and then we require them to give us a certificate that just says we have all these. From my experience, it's not ever the case that then they furnish a copy of the policy and then we analyze the policy. I think in our ordinance, the best we can do is to require that they provide these insurances that cover all aspects of the project. And the only way you can protect yourself 100% is to then review a policy in any given case.